After drawing criticism for taking large donations from lawyers with celebrity clients under investigation by his office, Cyrus R. Vance Jr., Manhattan's district attorney, said on Monday he would no longer accept contributions from lawyers with pending cases. Mr. Vance also said he would not solicit contributions in person and would ask campaign officials to keep the names of donors secret, adopting the same campaign finance rules that candidates for judgeships must follow in New York State. Mr. Vance's self-imposed ban exceeds the recommendations contained in a report released on Monday by the Center for the Advancement of Public Integrity, a think tank at Columbia Law School. Mr. Vance had asked the center in October to study the influence of contributions to prosecutors' campaigns and to find concrete ways to counter the public impression that donations could sway a district attorney's decisions. At the time, Mr. Vance was facing a torrent of criticism over his decision not to prosecute the Hollywood producer Harvey Weinstein after an Italian actress accused Weinstein of groping her during an interview. He was also faulted for not pursuing charges against Ivanka Trump and Donald Trump Jr., who were under criminal investigation over allegations that they misled buyers interested in the Trump Soho condominium project. Mr. Vance's campaign had received large contributions from defense lawyers who represented Mr. Weinstein and the Trumps. The Public Integrity Center's report recommended that lawyers with clients facing criminal charges in Manhattan donate no more than $320 to a candidate for district attorney, though that cap would be lifted 6 months after a case was resolved. Partners in their firms would be limited to $3,850 in each election cycle, roughly the same general election cap as exists for borough president candidates under city rules. The report said, "My campaign will meet and exceed these recommendations," Mr. Vance said in a statement. Donations to candidates running for district attorney from defense lawyers are legal in New York and have been made since the 19th century. Individual contribution limits are based on the number of voters in a county. In Manhattan, the legal donation limit in a general election is $50,000. The recommendations in the 38-page report are aimed at limiting the influence of donations on the criminal justice system. The report said district attorneys should never accept donations from people under investigation or indictment, or from assistant district attorneys. It also recommended prosecutors enforce a strict separation between their campaign and office staffs, so that the district attorney's office has no knowledge of who has offered financial support. The report suggested limits of $250 for lawyers with pending cases in counties with smaller populations. Perhaps the most radical recommendations involved keeping the list of donors secret from sitting district attorneys, and banning prosecutors from soliciting contributions in person. Mr. Vance said he did not expect other district attorneys in the state to follow his lead, but he believed the blind approach to raising money would allay public concerns that lawyers could buy leniency for their clients. Barring donations from lawyers with clients facing criminal proceedings until 6 months after the case is resolved is a sound, solid rule that makes sense, he said. He said he will abide by these campaign contribution rules even if a challenger does not. That's their decision and that's for the newspapers to ask them about, Mr. Vance said. Jennifer Rogers, a former federal prosecutor who leads the Public Integrity Center, said the study found a wide variation in practices among the state's 62 prosecutors' offices. Most do not have any written policy regarding campaign donations, she said. If all the state's district attorneys voluntarily adopted the recommendations, Ms. Rogers said, it would go a long way toward eliminating the appearance that contributions can buy a prosecutor's decision. But she said a voluntary system has limitations. Some incumbents and challengers may not opt to follow the guidelines. Only a change in state law would ensure everyone across the state is playing by the same rules, she said. It definitely is something that should be addressed by the legislature, she said. Susan Lerner, the executive director of Common Cause New York, called Mr. Vance's decision a really strong step in the right direction, but she said the legislature should now codify the recommendations into law. Even if voluntarily followed by all candidates, the guidelines may not remove the influence of campaign money entirely. For instance, under the center's recommendations, district attorneys would still be allowed to attend fundraising events where they could give campaign speeches. They would be able to see who attended the event, but in theory the candidate would not know how much each person donated. The report also acknowledged that there is no way to stop a candidate from learning the identities of donors through public websites maintained by the city and state election boards. In the case involving Trump Soho, Mr. Vance's chief assistant at the time, Daniel R. Alonso, directed the campaign to return a $25,000 contribution from the Trump's lawyer, Mark E. Kasowitz, before a meeting with Mr. Kasowitz. A year later, however, Mr. Vance's campaign accepted a $32,000 gift from Mr. Kasowitz, only to end up returning it after reporters highlighted it. Scott D. McNamara, the district attorney for Oneida County, said capping donations from defense lawyers with active cases would be easier for prosecutors in smaller counties, where there are few large contributions. But in the end, he said, it would depend on the honor system. It's only as good as a candidate's word, he said.